Hi folks, you're with Tacitus Today, your pushback channel, and thank you for joining this radio, audio, no pictures live stream. Please listen to this presentation, this essay as you're driving along in your car or your truck or on the train. What I'd like to talk about in this essay is how juries, or the use of juries in trials. Juries used to be and were part of a very essential component of preventing state tyranny. So this idea that a judge could just throw you in prison and that's the end of it. This changed, or jury trials were brought in so that, jury of your peers, 12 men, good and true, and all this sort of stuff. This was brought in to protect against state tyranny and to be judged by your peers. Now, if your peers then found you guilty, there was an idea that the government wouldn't have to, or the state wouldn't have to accept or take responsibility for it. Well, you've been judged by your peers. Now, when people lived in, this is coming from Britain and so on, but when people lived in the same village all their lives and multiple generations and so on, everybody knew everybody, or knew about somebody's family or situation. So you were being judged literally by your peers. That's of course changed now. People moving around. Big cities. People don't know that they may be aware of, as in through the media if they're a public figure. But generally, people don't know who they're judging. This is considered. Juries don't know that. This is considered in some ways a positive, because then there's no personal conflict of interest. They may personally like or dislike the accused, for example, and that may in turn corrupt the impartiality of their decision making. Nonetheless, juries were there to prevent the tyranny of the state. Now, say in Britain in for example, the early 1800s, so we'll go back a way here, and this is when the struggle over the writ of habeas corpus was going back and forth. It still hadn't fully settled at the time. This is the arbitrary capacity of the state to arbitrarily detain somebody without clearly charging them, because if you can't make a clear charge, then they can't defend themselves. So habeas corpus was A, the ability to arbitrarily detain, and B, to detain without clear or proper charge. That was still, it was there, but it was still sort of become it was unnecessarily flexible at the time. It hadn't really solidified as to what it became later on. Now, the penalties for really some quite minor offences were quite severe. The death penalty, or long 20 years of hard labour, being deported to the colonies, these sorts of things. So the penalties were quite severe. The death penalty, being the most severe. For crimes today that maybe would only get you 6 months in prison, but back then there was a need. But this is before there was no police force, by the way. Back in the time, there was sort of a local sheriff or somebody like that. But then they would have to deputise citizens as a posse, which you would see in the movies about the Wild West. The posse goes chasing after the stagecoach robbers or something like that. But there was no police in the sense that we understand it today. So the governments of all over the world, wasn't just in Britain, or they would have unusually harsh penalties in order to be a deterrent. So your likelihood of getting caught isn't really that high. But if you're caught, you're going to be killed. So this was meant to be the deterrent. So it's the sort of deterrent you have without having a police force. The severity of the sentence. Now, what they found in Britain was that unless the crime was a severe crime, juries just plain wouldn't convict. Even if the evidence was, the person probably was guilty on balance, but if the penalty was severe enough, juries wouldn't convict. So you could say this is early ideology in here, in the sense that the facts suggest guilt, but because the state had penalties that were such out of kilter with the severity of the crime, juries just plain wouldn't convict. So, and there's a sign. In fact, I took a photograph of it some years ago. I was driving through Dorset. This is a county of southern England. And I was driving through. It was actually a hot day, so there's a lot of like vacationers and things around in summer. And because the traffic was moving slowly, I went across a one-lane bridge that still had a sign on it from, I think, 1802, which is whoever shall so injure, this is the term they used, injure this bridge will be forthwith transported to the colony of Botany Bay, which is Australia. And they still got that sign there, for goodness sakes. And that was considered quite a severe penalty as well. So often juries would struggle to convict. So judges would say, well, it will either you're either going to be killed or transported to the colonies, and then the jury had to decide that. So the juries would decide on the lesser one. So very, very reluctant were the juries to go. So this was an example of how the jury was a break against state tyranny, state overkill, state overreach. But it wasn't necessarily whether the guilt or the innocence of the party was there, but rather the severity of the punishment. Let's look at juries today. Now, I would, if someone had asked me 25 years ago, 30 years ago, 40 years ago, that was it possible to stack a jury? Maybe in some one-horse hick town, maybe it was possible, but I would have thought, no. How would you stack a jury? I mean, would you go to people and say, listen, we'll only let you on the jury if you'll promise to convict the person or to exonerate? And there's stories about mafias, mafia goons and bosses getting to all the jurors and threatening them with, this, that, and the next thing, death and destruction, or bribing them, as the case may be, to make sure the mafia mob boss got off. There's a lot of movies around on that. I don't know how true they are, but one would reasonably assume that must be happening. The capacity of key witnesses to magically disappear, would suggest that jury tampering is going, and there are quite severe penalties for jury tampering. But today I've noticed, and I've gone through sort of quite a few cases where juries are prepared to act along ideological lines. There was a recent case where somebody was a straight white person misgendered a trans individual, and this was a matter that the prosecutors took up. Legal aid funded it, and it was drawn into a court, and a jury of 12 people decided that this person was guilty of a hate crime. Now, looking at certainly the evidence, I know I wasn't in the court, by the way, but looking at the evidence that was available in the public domain, to me, it's inconceivable that a jury could have reached that verdict. Inconceivable. Now, the penalties weren't severe in the sense that the person wasn't, person convicted of the hate crime. It was like a fine and community service. The legal process probably would have bankrupted them, but anyway, so that's punishment enough. The stress of being dragged through the legal system like that. So, but and I've noticed that juries, there's no problem in stacking a jury. How would you get 12 people? Seriously, how would you get 12 people that would agree that misgendering a trans person is a hate crime worthy of penalty? I mean, how would you get that? I don't know if that's even possible. I can't imagine it would be. But they can do this, and also ideological. These because these, like, a hate crime is an ideological situation. It's not a defined thing. It's an ideological, and similarly, so ideological law has crept into all legal practice. And starting off in the divorce courts where it began, and it wasn't stopped or checked then, and it's simply expanded. And the people that flocked to that at the time were emboldened to spread out into all legal jurisdictions. Now, I've got some. I'm not a lawyer, but I've spent quite a bit of time preparing documents, going into court and so on, mainly in contract law. So I'm aware of legal procedures and aware of the need, certainly in contract, of absolute exact. You can't put something forward as evidence unless, or you can't make a claim in court unless you can produce the evidence and there is an impartial, agreed definition on the evidence or its meaning or import and so on. And the judges are quite rigorous. And I've seen lawyers come in sort of pretty half-assed, and they'll try and stick an ideological issue or sort of just something that isn't supported by the evidence. And they'll get told off and ticked off and finger wagged by the judge. So there's a need for exactitude. It has to be very clear, very precise. You must have your evidence. You must have your documents. Everything must be, it's a paper-based legal system. Everything must be, just so. Otherwise, you can't use that as evidence in the court. You can't just have ideological stuff. Now, I've also watched cases in, say, the divorce courts. Now, the difference between ideological law and evidence-based law is I mean, it's a chasm. It's wider than the fucking Grand Canyon, for goodness sakes. So, say this is an example of an ideological something in an ideological court. This is a divorce court thing. So the lawyer representing the mother who's being funded by legal aid, or the woman, the wife who's being funded by legal aid. Well, we're concerned, this is talking to the judge, we're concerned that Mr. Smith may or could be violent towards the ex-wife and the children. And so for that reason, it's possible that he might become violent. And there are studies have shown that this violence can occur and may occur. And so therefore this puts the woman and the children at risk, using all the cool speak language, at risk, violence, danger, threat, at risk. And so we ask that the Mr. Smith be thrown in prison or something, or be prevented from coming within 200 meters of Mrs. Smith. So, all right, yes, the judge nods. The danger, the risk, the danger, the violence, the oppression. Now, let's just look at this for a minute. The study that the lawyer cited is actually done by a lesbian gender studies academic that has an online virulent history of being anti-male, anti-straight white male. All gender relations have a power imbalance, which is in itself violence against women. The family is an evil unit that oppresses women and so on. This is a radical off the planet lesbian activist. But the lawyer's allowed to use this as well. That's proof that all men are evil. And therefore we have to control Mr. Smith. Mrs. Smith is at risk of violence. And you've got to say it with a slight lesbian. So it's all ideological. Now, in a real court, in the contract law court or a real court, the judge would go, okay, what evidence do you have that Mr. Smith has been violent or will be? Or none. So that study you mentioned, that's by a radical activist. You're not citing that as balanced evidence, are you? I thought I'd give it a go with it. So the judge, well, I'm dismissing that lawyer. That's nonsense, and how dare you bring that into my court and without evidence. So ideological courts, you're allowed to assert the ideology, and you don't have to provide the evidence. And so what I'm noticing is a lot of courts where there are juries, where this ideological law, hate crimes, things like that, where there are issues, the jury is deciding in favor of the ideology, not of the facts. And I don't know how it's possible to get jurors in there that 12 jurors, how they will just decide on the basis of the ideology. I don't know how it's possible. Now, it must mean that the lawyers representing the accused are doing a piss poor job. Are they only accepting, pink-haired lesbians or something in the juries? What's going on here? To me, it's inconceivable or impossible to find guilt on these ideological crimes, but they are, and with increasing reliability. Now, the only way you can do that, I believe, the only way you can do it is to stack the jury. Now, sure, the judge is an activist, the prosecutor is an activist, the lawyer representing the accused has to be hopeless, fucking hopeless, because you get the choice of jury selection. Now, the only other option I can assume is that the pool of jurors that are brought in, because you could pick 12 jurors, but you may have 30, 40 or something potential jurors there, that they're hand-picked activists that are being put into the jury pool, so that no matter who you pick or who you reject or whatever, they're all going to be activists anyway, and they will all decide based on ideology. Now, even a worse interpretation is that no matter whether you do a rando pick of the population or not, that you're going to somehow end up with 12 activists that are totally 100% on board with trans ideology and so on. I don't buy that even for a minute. So what we're really looking at is a stacked jury, and how they stack it is almost irrelevant. But you're looking at do they, say in the case of a transgender hate crime, do they go to a trans nightclub or so, or a trans activist meeting group and say, okay, we need 12 jurors, you 12 will do? I mean, how do they do it? I mean, how could you guarantee that 12 people will ignore all the evidence and just go with the ideology? How do you do that? It can't be that easy. Now, in anything where we see ideological law permeating, it could be in rape cases and whatever, we see this idea of, well, we can't rely, because in the case of, say, rape trials, as a case, the penalties can be quite severe. The penalties are more severe than, like, if you're a non-white male and you go around murdering people, you'll get less time in prison than the straight white male will, who's accused of rape. So you can get 15, 20, 25 years for these rapes. Now, because the penalties are so severe, juries are reluctant to convict given the stakes are so high, particularly where it's like 51% of the evidence suggests that possibly it did happen. But there's no slam dunk here, far from it. So juries are reluctant to, even female jurors are reluctant to convict when the stakes are so high. So rather than than have a lesser sentences, the various discussions around juries are get rid of juries altogether, because we need a reliable way of convicting people who are accused of certain crimes. Ideological crimes, because it's this is not an issue of, say, rape. It's an issue of gender power relations, and this ideology of gender power relations, that is the issue in the trial, not whether something did or didn't happen, not whether there's evidence or not evidence. Gender power relations are the issue, and so this is why it's become ideological, and why activist prosecutors are bringing cases to court that really are, on an evidence basis, are completely unwinnable, but on an ideological basis, they're fired up with the passion of ideological fanaticism to bring these cases to court. So either do away with juries altogether, or hand pick juries that are sensitive to women's issues, for example. So the idea of stacking a jury and hand picking people that will be relied upon to produce a certain verdict, this is already out there. It's already being talked about in the right circles. So coming out of the Trump trial, based on the evidence, it's inconceivable that he could be found guilty in any of those counts. Yet somehow they've managed to, they've got the activist prosecutor, they've got the activist judge, activist court officials, all that sort of stuff, and somehow they're able to stack the jury to get a verdict there. Now, again, remember, juries were there to prevent state tyranny, but we're now in a situation where, given that no one suspected in the past that ideological law would begin to dominate legal practice. And I'll come back in a minute to theological law, if you will, or canon law. But no one predicted that could possibly happen, but it has. So we've got evidence-based and fact-based law and ideological law. Now, I figured that ideological law may just stay in the divorce courts and not go so. But now the practices that 25 years ago I observed in the divorce courts, the insane ideological sort of predetermined prejudicial ideological outcomes they are prescribing, have now permeated all areas of law, or many of them anyway, including criminal law, and certainly permeated and infiltrated to prosecutor departments and public defenders. The whole thing, legal aid, everything. So we're now in that situation where, because ideological law has come along, which no one thought it would, the idea of stacking a jury is consistent with pursuit of ideological outcome. Well, we can't guarantee that the jury will make a decision we want, so we'll just stack it. We can't guarantee that people will vote in the way we want we do, so we'll rig the election. We can't guarantee this or that organisation will do it, so we'll just rig the board of directors, and so on and so on. So this is now considered acceptable practice, because populism, for example, people voting for a government that they want or policies they want, that's now unacceptable. So rigging elections, everything like that, rigging juries, stacking juries, all of this is now acceptable practice in the new paradigm, and we should all be very, very fucking scared by it. Now, I'll come back to the days of ideological or canon law. Not ideological, religious or canon law, theological law, call it what you like. These are the days when everyone believed that there were witches running around casting spells on whether your cow would give milk or not. That's an extreme thing, but nonetheless, the idea that the influence of the devil was everywhere, and the struggle was for good and evil was struggling. It was always the ultimate battle that was out there. And evil was had many advantages. It was, if you were lucky, it was the devil, the luck of the devil, and only severe measures by good people could prevent this evil from taking over. And it was the fight to the death between good and evil, and so on. And so, because evil was all pervasive and it was always just about to take over, only the most brutal measures to fight evil, could be employed or should be employed, and it was justified to do that. So the idea you could just accuse someone of being, they didn't turn up for church on Sunday. This is during the times of the Inquisition. Didn't turn up for church on a Sunday, that they could be declared as being, in league with the devil, or having congress with demons, or getting buddy with the devil's goons and henchmen, and so on. Therefore, so really, people's sophistication in terms of law administration of justice today, I don't think is much more sophisticated than it was, back in the days of the days of the Inquisition. If you want to look at what is a sophisticated progressive society, what is the height of human progress? It's the ability to have completely independent, incorruptible, impartial, evidence-based, tested evidence-based courts of law. That I think is the ultimate expression of an advanced society. But we're actually going backwards at a rate of knots there. And the Trump case and other cases around the US show that stacking juries is now acceptable practice if you get the ideological outcome you want. This is insanely scary, and I don't see really anyone pushing back against it. The globalists certainly want it this way. The more superstition there is about far right, then the more power the globalists have. You've been a Tacitus today, your Pushback channel, and thank you for listening.